Further developments, the rising number of business closures due to financial distress has sparked alarm. It is noted that 109 businesses were forced to shut down in January this year, marking a 35% surge from last year. The matter has resulted in calls for feasible solutions. Director for Dispute Resolution at Cliffe Dekker Hofmeyer, Mongezi Mphahlwa, discusses this with us. Thank you so much for your time, Mongezi. What has emerged as the leading issue behind the spike in the number of business closures?
Afternoon, Tunisang, and to your viewers. I mean, we all know that the economy is under strain at the moment, and businesses are struggling, and and are going through financial distress. So I think we can all agree that the economic situation globally, not just nationally, is affecting not just companies but consumers in general.
Absolutely. Now let's talk options to get out of sticky situations. Talk us through the difference then in the elements that are provided within the landscape. Liquidation and business rescue, what's the difference?
So with a liquidator, liquidation, a liquidator is appointed to wind up the affairs of a company by taking possession of the assets and disposing of them for the benefit of the creditors. So on the other hand, a business rescue practitioner is appointed in order to give the company some breathing space and to enable it to restructure its affairs and allow it to return to solvency. So you'll recall that the New Companies Act took effect in 2011, some 13 years ago. And its stated purpose is to promote innovation and investment in South African markets and provide for the efficient rescue and recovery of financially distressed companies in a manner that balances the rights and interests of all relevant stakeholders such as employees, creditors, trade unions, etc. So those are the distinctions of the two options.
Is there a better evil between the two, and how does one then make a determination for their business based on how distressed they are financially, whether to go the route of liquidation or business rescue?
Well, firstly, with liquidation, companies are usually, insolvent, which means they technically, either cannot pay their debts as and when they fall due, or it is just inequitable for the company to be wound up, for example, when there's an irreconcilable deadlock in the company's board of directors. On the other hand, with business rescue, the business rescue practitioner is appointed in order to give the company breathing space, as I've said. And it's really to turn around a company that is capable of being rescued, as opposed to a company that is insolvent that has to be liquidated.
Based on that, Mongezi, can business rescue then lead to liquidation, and what then would be the benefits of this?
Yeah, well, a business rescue can lead into a liquidation, for example, where the business rescue practitioner concludes that there's no reasonable prospects for the company to be rescued. In that case, the practitioner must apply to the court for an order discontinuing the business rescue process and placing the company into liquidation. Or it also happens where there were grounds to believe that the company that's in financial distress could be rescued, but those grounds are no longer in place. And in that point, the business rescue will have to inform the court and all affected persons and file a notice of termination of the business rescue process. But there is no benefit really in winding up a company in both instances, as it leads to job losses and the dissemination of assets. So the benefit is likely to be to the creditors, but even then, they are most likely to receive a dividend of 20, 30 cents in the rand on their proven claims. So the benefit really, there's not much of a benefit in a company going into liquidation. Worst case scenario is that they are likely to make a contribution towards the cost of winding up that company if there's absolutely nothing in the company. So winding up is not always the best option, but with that being said, business rescue is not available to every company, especially terminally, insolvent companies.
Yeah.
As you know, we've seen in the past, companies will go into, business rescue, which can be an abusive process as well, when it is too late to turn it around.
That's an interesting element, because then I want to talk about the role of a business rescue practitioner. We've seen in previous cases that too can be a role that is abused. Talk to us about the responsibility of that particular practitioner.
So during business rescue, the business rescue practitioner has full management control of the company and substitutes the existing board and pre-existing management team. They may delegate any of their functions to any person who was part of the board or who was part of management, and may remove such persons. So his role is really to come in and investigate the company's affairs, the business itself, its assets, the financial situation, and having done so, consider whether there's any reasonable prospects of rescuing, the company. He or she is obviously accountable to the creditors, the employees. So he needs to report to all these people. So lastly, the most important role that a business rescue practitioner is to play is to develop a business rescue plan for consideration by the creditors on how he or she intends to turn around or restructure the business so as to return to solvency.
As a parting shot, we have in this country seen even the likes of state-owned entities going into business rescue. Critical lessons that we should have learned at this point in the economic landscape.
Yeah, among the key lessons we've learned through companies going through business rescue is that cooperation between all the stakeholders of the company in distress is important. This includes all creditors, the employees, trade unions, etc., as I've mentioned, who are to, really they need to support the turnaround initiatives proposed by the BRP. But equally so, it requires an open and transparent engagement between all the relevant parties throughout the process. That's the first. The second is early detection of financial distress, and taking proactive measures is critical on the part of the board, as often we've seen that companies will seek legal advice when it is too late, or file for business rescue, and by that time the company is hopelessly insolvent and is actually not capable of being rescued. The third one is that, in most instances, the success of business rescue is dependent on companies in financial distress being able to access post-commencement finance through funders such as the banks and other financiers who are in a position to inject cash into the business so that it is able to trade again, so that it is able to pay its operational costs such as suppliers, salaries, etc. And in that way, it is also then able to return to solvency.
Thank you so much for your input. Not too much of a complex issue, but a need-to-know basis, especially if you find yourself or your business in serious trouble. That was the Director for Dispute Resolution at Cliffe Dekker Hofmeyer, Mongezi Mphahlwa, talking to us about that concern raised of businesses in South Africa seeing a spike when it comes to shutting their doors due to financial distress.